Welcome to the Law Offices of Mary Kennedy. Today we are going to talk about the H1Bs and the layoffs that is associated with it and your options that's available. The situation that's happening with the layoffs that's happening, especially in the tech industry. Even I had a consultation 2 days before, a client who walked in and then said that he was here in US for the 12 years and this is the first time that he has been laid off and he's getting closer to the 60 days period. So what should I do in those situations? Some of the simple terms. If you have your I-94 that's valid, then the 60 days period is still available. If you can find an opportunity for another employer to do that H1B transfer, that should be your first priority. Do not go into a panic mode to file for a H4 or any other status immediately, even prior to the 60 days. Practically speaking, it takes a maximum of 10 days if you have a valid offer for a H1B prior to the 60 days, but definitely depends on the law firm that you're working with, the employer that who is going to be filing for, is there a valid offer. So, but the maximum is if you are in the last 10 days of your 60 days grace period, you should definitely be prepared to file your status to that of change of status, whichever is you're eligible for. The common ones are if you have your primary, another H1B, so then H4 is the first status, or the F2, or any other dependent status, L2, or whatever status that you can switch it, that should be a first priority. If not, then go back to the F1 status, that's a student visa that you could apply for so that you can continue to be studying. But that's not that as simple as such. You have to get an I-20 in a proper school, and then so many other details are needed. Try your best to switch to a status when you're in the last 10 days of your 60 days period. And coming back even before that, you can also evaluate an O1 status for you if you're in that outstanding category. That's also an option. It's not eligible for everyone, but definitely an outstanding category. So that's something you should consider. But again, you should find an attorney who can support you on that. Just in the simple terms, if you have to put it in, what are the details that you have to, or the list of documents that you have to look into it? The first thing is, irrespective of your employer withdrawing your H1B, even though it's taken into account, but the day of the 60 days matters is the last date of your pay stub. And sometimes you will miss it out if there is the 31 days, it's exactly the 60 days. So please make sure in February you definitely get this 28 days. Don't keep it as if I got laid off on February 1st, then it's going to be exactly April 1st. It doesn't work like that. It's exact 60 days that you have to reinstate it. So please pay attention to that. The another one that we have to talk about is the H4. What happens to the H4 dependents, H4 and the H4 EAD? The H4s are not dependent on an employer of the H1B. So, for example, somebody has prior H4 and the H4 EAD, still it's valid. So you don't have to file every time when there is another change of transfer of H1B. You don't have to file for your H4 and the H4 EAD, but there are certain places which we advise you to do it. The reason being, you get an extended 3 years of an EAD, so you don't have to wait for that. So if you have an eligibility to get a 3 years EAD, you should go for it. If there's so many changes that's happening, you should prioritize that. In this scenario, the 60 days. You are fine with the H4 EAD, but then what happens if you are not able to find an employer and continue your H1B? Then in that case, it becomes that you have, if you're changing your status to that of any other status, B2 or any other status, even an F1, definitely the dependence also has to be changed to that status. So please keep in mind, most of the time in so many things that happening, you miss to change the status, and we do every day so many places where I didn't I file for me to a B2 status, whereas my spouse and my kid has not been been filed for that. That's an independent application. For each one of you, B2 has to be filed separately if you decide to continue with your family over here. So please, these are all very important, consideration when you do this. One more thing from my personal, experience, I want to share it as layoffs are getting common, as well as you need to understand there is always an opportunity as you hold an experience over here to try it out and then see that if there is any other employer who are interested, do your best and educate yourself of the latest of whatever field you are in, enhance yourself to that of the skills, and find an opportunity to see that if you are finding any other way that you will find a right employment. If not, then you can decide to leave the country. Do not take any chance to just to continue over here without filing a proper status or not to be in a legal status. That's very, very important.
We have a situation. My friend wanted to change his job.
So here it is, so I'll explain it a little bit in detail, your question. Say you are continuing with the H1B of the current employer, and then you get an offer with a new employer, and you decide that, okay, they are going to be filing your H1B on a premium processing, for example, and then you get the approval from the second employer as well. So you hold two H1Bs at the same time. This one, you are continuing with the current employer, you are not even given a notice to him, whereas the second H1B also gets approved. So what situation it happens and which H1B I am, because the latest one has been approved, right? It all matters with the payroll of which company you are with. So what happens is you're continuing with the old employer even after the H1B of the new employer being approved. That means that you are still with the old employer. So the new H1B is not going to be effective unless you transfer into the payroll of the new employer. Then it becomes like this H1B is not going to be something that you cannot be switching between this and that. So it's a little complicated and a subjective question. So you definitely have to consult an attorney. And also most of the time we see that with the new H1B that, you would have signed an offer. So the new employer also could have been paying the USCIS fees, paying the attorney fees, because H1B fees is not going to be paid by the individual. So in that case, what kind of a contract you have signed and not accepting the offer? Is there any other contractual agreement you have with them? So these are all very many subjective questions that you have to find a right attorney to talk to them about this, and always make a right decision. What's the goal here? What's your decision? Because USCIS doesn't want to see anytime multiple offers, multiple H1Bs being filed for a same person, unless you intend to transfer your H1B to that of the new employer.
What will happen to H4 if it is filed as a one?
So any H1Bs and H4 and H4 EAD, recently we are seeing, especially with the Nebraska Service Center, the bundle along with the H1B premium processing, the H4 and the H4 EADs are getting approved. I am not sure how far it's going to be. This is just definitely the practice of the officer or practice of the service center, but we are recently seeing many of them getting approved along when they file it through the premium processing. But then we can't say that with assurance, and then you paying the fees of $3,000 closer to it. We are not guaranteeing anything. Unfortunately, it's not in our hands. Thank you for watching.